Good afternoon and welcome to the Findley Davies webinar. We're coming to you from our Toledo office where it's sunny, 95 degrees. We're in a nice room here, air conditioned. We're ready to go. We're going to cover a lot of ground today on the Affordable Care Act, some of the new HIPAA wellness rules, HIPAA privacy rules. We're going to be talking about DOMA and same-sex marriage, give you an update on that. So we have a lot of ground to cover. A few of you have submitted questions to us in advance, and we plan to address those during the course of our webinar or at the end of the session. And depending on the number of questions that we receive from you this afternoon, and you can send those to us via the chat feature on the right side of your screen, we'll try to reserve some time at the end to address those questions, and if we run long, we're going to stay on the line until we answer your questions. The four of us that are presenting today are all from Findley Davies, and I'm going to introduce them in the order in which they're going to present. Our leadoff hitter today is Laura Hoig. She's a senior consultant with Findley Davies, works here in the Toledo office, but she is the leader of our strategic wellness services, and Laura will be talking about the HIPAA the wellness rules under HIPAA. She'll be followed by Caroline Smith, who is a benefits attorney in our Cleveland office, and Caroline will be giving you a good update about the HIPAA rules. She's been spending a lot of time with many of our clients getting ready for these September 23rd deadlines, and she'll be going over that in detail with you. Following Caroline will be Scott Hamner, principal with Findley Davies. Scott works out of the Toledo office with me, and Scott, also a benefits attorney, specializes in a number of things, including flexible benefits design. But we rely on him very heavily for compliance support. And I'm Bruce Davis. I am the national practice leader for the Health and Group Benefits practice. I work out of the Toledo office as well. And so without further ado, because we are going to cover a lot of ground today, I'm going to turn it over to Laura.
Thanks, Bruce. As you all know, in early June, the Department of Health and Human Services, Labor, and Treasury Departments issued the final rules on incentives for non-discriminatory wellness programs in group health plans. And you're all likely very familiar with these because really what these final rules did was clarify elements of the 2006 HIPAA non-discrimination rules, and then just finalize some amendments that made it consistent under the Affordable Care Act. So these final wellness rules apply both to grandfathered and non-grandfathered plans. Since you're likely familiar with the 5 rules, today I'm just planning to briefly touch on, just overview those 5 rules very briefly, and then I'm going to focus more on the key changes that we've identified through helping our clients apply the clarified rules and try to navigate all of the information that was released. So as the HIPAA wellness rules, the final regulations follow the same general framework as the 2006 rules, and through that they identify 2 categories of wellness programs. The first, participatory, and the second, health contingent. Participatory wellness programs do not need to follow the 5 wellness rules. They must be made available to all similarly situated individuals. And things that are considered participatory include completion of a health risk assessment, Weight Watchers classes, rewards for health challenges, the types of activities and programs that you might offer that do not require someone to have a particular level of health to participate. Health contingent are the programs that rely on satisfaction of a health standard to complete the program or to meet a requirement. And here's where there was a pretty big change and a surprise to a lot of folks that the final rules came up with this subdivision of health contingent into activity only and outcome based. Outcome-based are what we traditionally thought of as health contingent, and that requires satisfaction of a health standard to earn a reward. So, for example, you have to hit a certain blood pressure measure to get an incentive. They've added another subcategory of health contingent, and that's called activity only. And these are things that historically would have been considered participatory. So this is where if you thought that you always had a participatory program, you might want to sit up and take note and think of whether it requires a certain level of health to participate in those particular programs. So, for example, things like a certain diet program where you have to eat certain foods, or even a fruit and veggie challenge. There are some conditions that may prevent someone from eating fruits and veggies. And even a physical activity 10,000 steps program would now need to follow the 5 wellness rules. So just a quick overview. The first requirement, and in this grid you can see we have the original requirement and then whether the final rules kept it consistent with the original rules or whether it clarified it or changed it. So the first is frequency of opportunity to qualify, and that's at least once per year, and that has stayed the same. So if you have an annual open enrollment process for qualification, you can continue with that practice. The second is the total reward for the portion that requires satisfaction of a health standard increases from 20% up to 30% of the total cost of employee-only coverage. Now that includes both the employer and the employee contribution. So look at the total cost of your employee-only coverage, and it increases from the 20% to 30% for health standards except for tobacco. If tobacco is included, you can increase the 20% difference between the 30% and the 50% can be allocated towards tobacco. So you can provide a little extra incentive reward for complying with being tobacco-free. And just a note, I mentioned that I'm going to focus on the key changes, and this is not, to me, I haven't been really emphasizing this with our clients only because the RAND employer study, the 2012 study that's quoted in the final regulations, found that the current value of health contingent rewards range from 3 to 11%. So employers haven't historically even bumped up against the 20%, so we really don't think that a lot of employers, they'll be more in the minority that will start to increase to this level of an incentive. The third requirement is that the incentives need to be available to all similarly situated individuals, and a reasonable alternative standard has to be made available to anyone for whom it's unreasonably difficult due to a medical condition to satisfy. And that is the same language that was included in the original rules, but there are some additional clarifications and requirements, and this is where the bulk of the changes reside in terms of these final wellness rules and what you need to pay attention to as you go into 2014. The fourth is the program needs to be reasonably designed to promote health or prevent disease and not be a subterfuge for discrimination based on a health factor. So you can't just say it's a health promotion program if really underlying it's determined that you're just really out to get those people who are at a higher risk. The fifth and final is the notice of other means to qualify, and it just means there's new sample language. This, once again, was one of the 5 original rules, and you have to make this disclosure available in all plan documents that describe the wellness program. So there is sample language available for that. So to focus in on the key changes of the final wellness rules, I already mentioned that health contingent is now subcategorized into activity only and outcome based. And really, as we've been working with our clients, they don't necessarily think that this is going to be a big deal, because if you think about the types of incentives you're offering for a walking program or for a special fruit and veggie challenge, it might be just a periodic incentive and probably is negligible in the context of any other premium-oriented incentives you're offering for the more traditional health standards. request for reasonable alternative standards mid-year. Now, this is one that has a lot of groups we work with taking pause, because you must provide a reasonable alternative standard even if someone mid-plan year comes to you and requests that alternative. So if it's come April and someone says, you know, I missed that qualification period, you still must offer them an alternative to receive that reward. In the same sense, the full plan year reward has to be provided to that individual once they complete the reasonable alternative standard, even if that happens mid-plan year. So in the past, typically employers would manage this that, say that the first quarter of the year they had to complete a series of coaching sessions, and they would provide the incentive upon completion of that series of coaching sessions. Now, there's very specific language outlined in the final wellness rules that the full amount of the reward has to either be retroactively paid to that individual or prorated through the rest of the year. And they have left some room for interpretation. They said that ideally that reward is paid within that same plan year. But if someone would complete a reasonable alternative standard on December 15th, they said that it could be paid out within a reasonable amount of time following the end of that plan year. Reasonable alternative standards have to continue to be offered until it satisfies the reasonableness test, which is a little bit vague. It ends with a participation-based alternative. So if you have, say, a weight-oriented requirement, that's the health standard, and you say you need to complete a course of Weight Watchers, then that would have to be given a reasonable amount of time to complete that, and then you would most likely be compliant because it's based on participation versus saying, well, if you reduce your weight by 20%, then you achieve this health standard. The final wellness regulations also acknowledge that many issues take a cycle of effort to improve. So, for example, with tobacco addiction, they specifically say you can't limit someone. So if they're not successful one year, you can't limit them and not allow them to complete a reasonable alternative standard the following year. A couple other notice requirements that are changes. Contact information for a reasonable alternative standard has to be included in all documentation that describe the wellness program. So you have to have somebody who's appointed that can answer questions and helping determine what's appropriate. Many of our clients use their third-party wellness vendors in this way. And then finally, the physician trumps all. So if you're trying to provide reasonable alternatives to your employees and they choose to go to their doctor can provide a recommendation that meets the physician's medical interpretation of what's reasonable for that individual. So I've rushed through that so that we can move on to HIPAA privacy requirements, but we're absolutely open to answering any questions after the presentation.
Okay. Hi, everybody. I am going to be talking about the HIPAA privacy requirements. And so whenever I bring up HIPAA or HIPAA's ever brought up HIPAA privacy, people's eyes just instinctively glaze over and roll to the back of their head. It's not the most exciting topic, but I'm going to try very hard to keep it as high level as I can, just give you a little bit of background, and then really hit the points of what you need to be doing now so you can really take something out of this. This is just our agenda. What is it and how it's applicable to you? It's been around since 1996. Why all the hubbub now? How can you comply, and why should you care? Okay, what is HIPAA privacy? The Privacy Standards of the Health Insurance Portability and Accountability Act of 1996, or HIPAA, became effective on April 14th, 2003, or 2004 for small plans. The privacy standards govern the use and disclosure of individually identifiable health information, which is better known by you likely as PHI. by covered entities. And covered entities are healthcare providers, healthcare clearinghouses, and health plans. And I'm guessing that most of you are really listening to this and are paying attention maybe because you are a health plan, you sponsor a health plan, and that's why HIPAA would be applicable to you. Some of you may be hospitals and really be wearing two HIPAA hats, one as a healthcare provider and one as a health plan, but remember under HIPAA these two things are completely separate. PHI is individually identifiable health information transmitted or maintained by a covered entity in any form or medium. And so this could be anything electronic, paper, or oral. If it relates to an individual's physical or mental health, the provision of health care to an individual, or the payment for that health care. On April 20th, 2005, and this is 2006 for small plans, the HIPAA security standards, which are part of the privacy rules, became effective. And the security standards govern the use and disclosure of electronic PHI by covered entities. How is HIPAA applicable to you? If you are a plan sponsor of a self-funded group health plan and then to a lesser extent a fully insured group health plan, your plan should have been complying with the HIPAA privacy and security standards since those effective dates, 2003 or 2004, and then 2005 or 2006 for the security standards. There are very few exceptions to HIPAA compliance. One, which I've seen used a few times but not very often, is if you have under 50 participants and you are completely self-administered, so no TPA at all. Everything is done in-house. That's one exception. And then some HIPAA accepted benefits are accepted from HIPAA privacy. They're accepted from the HIPAA portability rules. Some of them are accepted from HIPAA privacy, but not all. So really very limited exceptions to who needs to be complying with HIPAA privacy. Since 2003 or 2004, group health plans should have had the following HIPAA privacy documents in place. And again, note that fully insured plans may not have to have full compliance of this, but there are certain things that even fully insured plans need to have in place. So the general requirements are that you have to have a notice of privacy practices, privacy policies and procedures, plan document amendments, and this amendment is basically it either has to be within your plan document, or if you don't have traditional plan documents because maybe you're not in a ERISA plan, so you don't have necessarily having a plan document, you have to have this as a separate amendment in writing, basically certifying that the plan can disclose PHI to you as the plan sponsor for plan administrative functions. And then the plan sponsor certification, which is the absolute most useless document in all of HIPAA, and it is something that is, it's just a sheet of paper. It's a certification that certifies that that above amendment has been done, and that has to be actually in writing and documented and retained. Business associate agreements have to be in place between the covered entity and every business associate that you do business with that has access to your PHI. You have to designate a privacy official and have that in writing, and then perform HIPAA training and document that that training has been performed for all of your staff that have access to PHI. And security. So since 2005 or 2006, group health plans that use, disclose, or have access to electronic PHI should have also been complying with the security standards. And what you should have had in place since that time, you should have had a security risk assessment or analysis performed, and this needs to also be documented. And then you need to have security policies and procedures in place based on what you find in that risk assessment. Like the privacy official, you need to have a security official designated in writing, and your staff should also be trained on how you protect electronic PHI. So this has been around since 1996, and then 2003 and 2004 for the privacy and security rules. Why are we talking about this now all of a sudden? In 2009, the HITECH Act, which was part of the American Recovery and Reinvestment Act, modified the privacy and security regulations, and it created additional privacy protections. It enhanced requirements for business associates. It required increased enforcement efforts by HHS. It included breach notification regulations, what covered entities have to do, and now what business associates have to do in the event of a breach of unsecured PHI. And in January 2013, HHS published highly anticipated omnibus regulations, which you will note are effective September 23, 2013, which is now in 13 days. And these regulations were highly anticipated and also highly overlooked by a lot of health plans and plan sponsors. They came within weeks after the employer shared responsibility regs, and just really got overlooked by a lot of people until right now, because we are now 13 days away from the compliance date. So the omnibus regulations gave us changes to the breach standard and confirmed some of the things that were in the HITECH Act and made some changes to the definitions and some other things, and then required specific changes and additions to your notice of privacy practices, your privacy policies and procedures, and your business associate agreements. So all three of those things have very specific language changes and additions and some deletions that need to be done by September 23rd, 2013. How can you comply? What you should do is you should start by doing an internal audit and verify that your group health plan or plans currently have all of the required privacy and security documentation and items in place. Then by September 23rd, 2013, update your plan or plans, notice of privacy practices, privacy policies and procedures, and then business associate agreements. Now note that the notice of privacy practices, though it does have to be updated by September 23rd, how it's distributed, the timing of distribution depends on a few factors. If you have a company-wide intranet where you post benefits information, that notice has to be posted to that intranet site by September 23rd, and then the notice itself or a blurb basically about the material changes to the notice and where you can find the notice needs to be sent out in the plan's next annual mailing to plan participants, which is likely your open enrollment if you're a calendar year plan. Or if you do not have an intranet, then you actually have a little bit extra time to comply. Though your notice should be updated by September 23rd, you have until 60 days after the effective date to send out that notice or the blurb that I just mentioned. So you would have until November 22nd to send that out. And then policies and procedures need to be updated by September 23rd. And business associate agreements are generally by September 23rd, though depending on when they renewed, there's some leeway in some of them. You may have an extra year until September 23rd, 2014. You should also then conduct HIPAA training of staff within a reasonable time after this effective date. The regulations say, based on any material changes, staff should be retrained on those changes within a reasonable time. And if you are missing any documents completely, work towards completing them, and do not worry, you're not alone if you are missing these documents. Most people are at least missing some. And then consider any HIPAA language in your plan documents. The plan documents themselves may need amending. Why should you care? Nobody really wants to think about HIPAA, ever. But if you sponsor one or more group health plans, you have to think about HIPAA. The HITECH heightened HIPAA enforcement. HHS is now required to do audits randomly, and such random audits have begun. State attorney generals can now bring enforcement actions. Penalties are now required in willful neglect situations. Civil penalties have increased, and they are now broken down into 4 categories, reflecting increased levels of culpability from the I didn't know to willful neglect, and they can range from $100 per day per violation to $1,500,000 annually for all violations of an identical provision, though this can increase if there's more than one violation. So it's not just necessarily $1,500,000. And then criminal penalties can also be assessed in certain situations. You now have, again, a risk of a random audit, and now, due to the new breach regulations, if you have a breach of unsecured PHI, you have a mandatory reporting requirement to HHS. It's either right after the breach, or if it's a breach of less than 500 people, you have to keep a log and submit that log annually to HHS. So HHS is always going to be informed about any kind of breach. And depending on the nature of the breach, it can trigger an investigation by HHS. And then this investigation is now mandatory if any willful neglect is suspected. So you can then be penalized for the breach itself, and then you can also be penalized for not having policies, procedures, et cetera, in place once they come in and investigate all of your documents because of the breach. And I'm just going to give one quick example that I think really kind of sums this up. This is an example of the first settlement after the report of a breach, and it's Blue Cross Blue Shield of Tennessee. And the company, what happened in this case was that a company moved to a new building, and they were relocating their staff over a 4-month period. And in their old building, they retained a network data closet, but the security services were turned over to the building's property management group. So the data network closet they left was secured by just about every single thing you could possibly think of. It had biometric and key card scan security. It had a magnetic lock. It had additional door with a key card lock. It had everything, and guards and everything. And so you would think, yes, that is secure. However, the servers that they left were unencrypted. The hard drives were unencrypted, and 57 hard drives were stolen from this closet. And so because they were stolen and they were unencrypted, this was a breach. If they were encrypted, it would not have been a breach. That's the safe harbor. So because they were unencrypted, a breach occurred. They had to notify HHS. HHS came in, and not only were they penalized for the breach, but HHS said that they did not have appropriate administrative safeguards in place to protect their information, that they failed to perform a security evaluation in response to certain changes, and they failed to implement appropriate physical safeguards and having facility access control. So they were dinged for not having things in place and for the breach itself. So they settled with HHS for $1,500,000. And my final advice to you on this is that all items are important if a breach or an audit occurs. However, right now, you need to be focusing on your HIPAA or omnibus obligations, which again includes the Notice of Privacy Practices, Policies and Procedures, and Business Associate Agreement updates. And then after this deadline, you can move on and focus on the rest of your privacy documentation obligations, security compliance, training, and changes to your plan documents, because those do not have any hard deadlines except for the ones from, 10 years ago. So, so I would focus on, September 23rd first, and then move on. And that's it for me, and I am now going to turn it on over to Scott Hamner to talk about the Windsor decision and the potential impacts to your benefit plan.
Okay, the Windsor decision was a Supreme Court case. It was the decision was announced in June of this year, and I think there's been some misunderstanding about the impact of that decision. It is a very important decision, but it did not create full equivalency in all respects between same-sex marriage and opposite-sex marriage. That case was a tax-based case, concerned a state tax issue, and it concerned the Defense of Marriage Act. That Defense of Marriage Act was deemed to impinge on the right of the state to define marriage and violated the right to due process and the implicit equal protection provisions of the Fifth Amendment to the U.S. Constitution. So with respect to federal laws, and this is an important element of this, and it's a nuance, is with respect to federal laws, the Defense of Marriage Act was invalidated so that same-sex marriage would be recognized rather than ignored. The decision did not address the DOMA provisions that allow states to refuse to recognize same-sex marriages performed under the laws of other states or other jurisdictions. So, again, you have to understand that there's some constitutional foundation here. To some extent, we're dealing with rights that are different with respect to the federal government versus private employers, and it did not create, complete equivalencies between same-sex marriage and opposite sex. Okay. Now, Windsor preserved the right of the states to define marriage. I'll note that in Ohio, Ohio has a constitutional amendment that basically says Ohio's not going to recognize same-sex marriage. And the case left open a lot of issues, but did not create a countrywide uniformity standard. So this creates individual issues and administrative issues for employers. As going forward, we get into the next element here concerning a release by the IRS of a revenue ruling. We have to distinguish marriage from civil unions and domestic partnerships. Some states have what are known as laws concerning civil unions. Civil unions create some obligations, benefits, and rights between a same-sex couple that are similar to married individuals, but it is not marriage. And that's important with respect to application of these laws. Basically, a civil union created in a state will be recognized only in that state and is not recognized by other states. It's not the same as marriage. All right. Federal law after revenue ruling 2013-17. This is a revenue ruling that was issued by the IRS and tries to, it resolves a few issues. As it relates to federal income taxes or federal income tax issues, this ruling says same-sex couple will be treated as married if legitimately married in any domestic or foreign jurisdiction whose laws authorize the marriage of a same-sex couple. Hence, the tax treatment is not dependent on the state of residence. When Windsor was announced, it left open the question, didn't answer the question of what if a couple, a same-sex couple got married in, say, Iowa, which recognizes and allows the creation of same-sex marriages, and moves to a state like Ohio, which does not recognize same-sex marriage. Would that couple then be considered married for federal tax purposes? Revenue ruling 2013-17 resolves that issue and says for all purposes, that couple legitimately married anywhere will be treated as married for federal tax purposes, regardless of where they're then living. The quote here is just lifted verbatim from the revenue ruling, and I included it just because it indicates that, you know, the IRS was cognizant of the impact on its own administration, and this creates a uniform rule for tax administration. Revenue ruling also addressed qualified retirement plans. With qualified retirement plans, and qualified are those that meet certain conditions of Internal Revenue Code 401 and related sections, says a qualified retirement plan must recognize the same-sex marriage that was validly entered into a jurisdiction whose laws authorize the marriage. What this effectively means is it affects spousal rights to retirement benefits. Since ERISA, there's been kind of a federally mandated spousal right with respect to retirement benefits. So, for example, in the average, what's known as a profit-sharing plan, if the participant wanted to designate someone other than the spouse as beneficiary, spousal consent would be required. In a defined benefit plan, there's a mandated 50% joint survivor annuity to the spouse, which can be waived, but only waived if the spouse consents. So, on or after September 16th, 2013, a qualified retirement plan must recognize the same-sex marriage, and as it relates to the spousal rights to retirement benefits, treat that same-sex spouse as a spouse requiring that consent for alternative appointments. There's still unresolved issues. And again, as I said earlier, Windsor just didn't create a full equivalencies between opposite sex and same-sex couples. And I think there's been some confusion about that. It also didn't mandate that same-sex employees with same-sex spouses get all forms of benefits. And there's still just these unresolved issues. So, for example, the IRS basically punted on dealing with retroactive application to qualified plans pre-September 16th, 2013. So, for example, a participant with a same-sex spouse, let's assume, died, had appointed children, or somebody not the spouse, as beneficiary, was paid out. Does the plan sponsor have exposure for having made that payment irrespective of not having any spousal consent? Nobody knows the answer to that. Issues regarding retroactive application to other benefits. You could have the same kind of issue about, let's say, a health and welfare plan says a spouse is eligible for a benefit, but doesn't define what a spouse is. The question will be, is that same-sex spouse treated as a spouse for that benefit? Many years ago, most plan documents started being written with some fail-safe language regarding independent contractors, or those who had been deemed to be independent contractors, stated differently, not employees. The fail-safe language said, if we treated you as not an employee, we treated you as an independent contractor, or whatever, even if you're found by a court or some other government authority to be an employee, you're not going to be eligible for the plan until we say you are. I'm pretty sure that no health and welfare plan has that fail-safe language, or we have a few qualified plans, I know because I wrote them, that have some definitions regarding spouses, but not all. So there's some exposure there. Application to state government retirement plans. Actually, you probably should put in here state government and church plans. State government and church plans are not subject to ERISA. They're excluded from certain provisions of the Internal Revenue Code regarding vesting, joint survivor annuities, those death benefit rules, etc. So, what's the answer with respect to same-sex couple rights, with respect to qualified plans of governmental employees or church plans? Again, unanswered. State income taxes. And I think there's really two issues here. Most states, including Ohio, define their taxable income by reference to the federal definition of adjusted gross income. So if it was in AGI, it's in taxable income for the state. So if we have a same-sex couple that files a joint return for federal purposes, they've defined their taxable income in one way. But when we get to the state may not define marriage as between two same-sex couples. Again, I'll refer to Ohio. And so there's, perhaps one issue with respect to just even the definition of what's in taxable income. But the second issue is eligibility to file a joint return. When I looked last week at the Ohio income tax website, I found no answer with respect to either A, defining marriage, or B, eligibility for filing tax returns, no description. And I suspect it's still a little bit early in that respect for the state to put something out. So, but it's an open issue. Marriage for Family and Medical Leave Act. Interestingly, the DOL could say in an announcement, its enforcement policy is basically they will look to state law to define marriage. So in contrast to federal tax law and what the IRS issued, the IRS said married anywhere, married for all federal income tax purposes. FMLA, it depends on state law. Now, what this means is the practical impact of this would be, for example, an employer that had provided for what I will call FMLA-like equivalence for a same-sex couple if the employee took time off to care for an ill same-sex spouse. That really would not be FMLA leave. And if in a subsequent period the employee had an FML leave reason not for that same-sex spouse, but for a child or something like that, then the period of time they could be off would be with reference to FMLA, and there would not be an offset for the time taken off for the same-sex spouse. So you can't coordinate. Now, there's some practical elements to that, of course. You know, I think in either case, the employer could require the employee to use all their PTO time first. And let's face it, most of us need to work for a living, and, you know, there's only so much time we could be off without pay. But it does present that issue of, you know, coordination and offset, and the DOL's position is state law. So still some unresolved issues, still forcing the employer to make some decisions. In conclusion, I recommend that every employer honestly evaluate all their policies with respect to the same-sex marriage issue and develop their own philosophy about how they want to deal with it. Some of it is a legal issue. Some of it's just a philosophical issue. For example, ACA, the Affordable Care Act stuff, does not require coverage of a spouse, whether it's opposite sex or same sex. So there's an example of how do you, the employer, want to resolve that issue? Who do you want to cover? And I think it's just better to resolve some of these issues and decide your what I call philosophy, before you get pressed to do so by an employee, demanding some particular right. Making a decision in haste and under pressure will often result in a bad decision. And it's probably better just to decide in advance and then communicate it than to wait. So with that, I'll turn it over to Bruce.
Great. Thank you, Scott. Before I shift gears onto this next slide concerning the Affordable Care Act, I just say a couple things. As you're seeing, we've packed a lot of information into a very short amount of time. And our individual contact information is going to appear at the end of the presentation. So we'd urge you to, as you think about what you're hearing and perhaps learning today, feel free to give us a call or email us if you have any specific questions. But I would also offer a caveat to that we are a human resources consulting firm and not a law firm. So we're not here to give legal advice. So we will always couch what we talk to you about in terms of checking back with your legal counsel and tax advisors. So again, you'll look for our contact information at the end. So moving ahead into the Affordable Care Act, the first thing that's going to be coming up on the docket here is the DOL exchange notice. I can't believe it's only 3 weeks away to October 1st. This notice, as you probably are aware, needs to be provided to all employees, both part-time and full-time employees, even if they're not actually enrolled in the plan. One of the things that we've been asked about is, do you have to provide the notice to retirees? And although you're not legally required to provide the notice to retirees, I start to question why not communicate to retirees about exchanges. We're here in Toledo, Ohio. We get a lot of the news about the bankruptcy in Detroit nearby. There's a lot of talk about how they're going to perhaps, to mitigate their retiree health care liabilities that are unfunded, send those retirees into the state-based exchange. There's also news just in the last couple of days about IBM sending 110,000 Medicare eligibles to an exchange. The issue I have with that is that it is not the public exchange. It's not a federally facilitated or state-based exchange. What they're going to be doing is working closely with Towers Watson's Extend Health, which is a private exchange, and they're going to be using a defined contribution approach to provide monies to those retirees, and they can then shop on Extend Health for coverage that would best meet their needs. So it's a little different than saying that they're going to send people onto a state-based exchange. So the point is, I think, is that for those of you that have retirees, think about crafting some communications to them to to let them know what's going to be happening as the exchanges, the public exchanges, open their doors October 1. A couple things that we're talking about on some of the drafts of letters that we've helped clients with is just reminding employees that whether they are in fact eligible for federal premium and cost-sharing reductions. You know, if your plan is offering, you're offering minimum essential health coverage that meets both minimum value and affordability requirements. Of course, the employee is not going to be eligible for a subsidy in theory. But we also recommend that you remind employees that if they were to disenroll from your plan, they can only do so during open enrollment. And if they were to see if the grass was greener on the other side with the exchange and they were dissatisfied with the exchange coverage or rates, they can't come back onto your plan until the next open enrollment. And those are obviously IRS rules and not yours. But I think it's wise to probably communicate that in your cover letters in which you transmit the exchange notice. I'll also say, too, that some of the clients have been asking, could we kind of have an omnibus cover letter that would transmit not only the DOL exchange notice, but also the Medicare Part D credible coverage notice. We shouldn't forget about that. That has to be done October 15th. Yet another one, right, Caroline? Mm-hmm. And also the transmitting the HIPAA privacy notice. So some clients are thinking about kind of killing three birds with one stone, so to speak. Exchange queries, as you're probably aware, there's guidance out there that talks about how these federally facilitated exchanges, and that's what we have here in Ohio, how they're going to be verifying an applicant's eligibility for qualifying coverage. And it looks like they'll be following some type of random sampling technique. I can't tell you how often you should expect to be contacted by HHS or the exchange operator to verify an applicant's employment eligibility for coverage, whether your coverage met minimum value and affordability tests, but you should be ready to handle those queries. We continue to recommend that you document your people's eligibility for coverage and, of course, any waivers. So if someone has been offered coverage and they've declined, make sure you have a document, a record of that. SBC, summaries of benefits and coverage. We can't forget that those are also going to be due, again, this open enrollment. This year, the format remains the same with the exception that there's going to be language in there for you to indicate whether your plan does provide minimum essential health coverage and whether it provides coverage that meets minimum value requirements. So again, don't forget about the SBCs. I'll call on Scott a little bit here on this. For measurement periods, we're all aware, obviously, that back on July 2nd, the Treasury, in their little blog notice, indicated that we were going to have a one-year delay in the employer shared responsibility rules. And so people had, been taking a lot of steps to get prepared for that. We've continued to advise people to, use this delay to get ready to be able to measure hours of variable hour employees and get ready for the reporting requirements that will come later. But Scott, I mean, when you think about the prevalence of calendar year plans, it seems to me that what we're seeing with most employers is that they're planning this initial measurement period to be October 1 through September 30. Is that your sense as well?
Yeah, no, I agree. I mean, the general thought process has been, I think ours has been, you want your measurement period to be a full year. Under the guidance, the measurement period could be for shorter periods, but it creates weird stability periods. Right. You could have a 6-month measurement period and a 6-month stability period, but you know, that means you're doing twice a year enrollments, and that just doesn't feel like a fiscally prudent from a administrative cost standpoint. And also, I think once you make a determination whether or not the part-time employee meets the full-time employee definition, and they may not, you probably want to keep them out for as long as possible, which moves you towards a one-year stability period, and it's a one-year measurement period. So, yeah, as a gross generality, you know, I think the measurement period is going to be a full year, and it's going to be that October through September kind of year.
Right.
Creating also a longer administrative period, which is probably useful just to get your ducks in a row to figure out who to enroll and not enroll.
Right, and so those of you that are very observant have seen the typo on that slide. We just did that purposefully so you could see who all was awake. So the initial measurement period would be October 1 of 2013 through September 30th of 14. So. We'll have that corrected when we post these on the website. I would just say that last bullet. I mean, we had a number of clients that had made changes in their workforce rules. Some were in the fast food, hospitality industry. Some were even in higher ed with adjunct faculty. Some were in retail and things of that sort. We've not really seen, Scott, anybody rolling back any of the changes that they made as the result of the delay that was announced. People that had reduced hours below 30, they didn't roll those back.
Sky's the limit.
That's right. So, anyway, moving ahead, getting into some of the reporting requirements, you're probably aware that there have been some guidance that was released on September 5th, and we're going to be going over that. The reporting requirements under 6055, 6056 were delayed a year. They're saying that the reporting for 2014, calendar year 2014, is voluntary or optional. So what they're now saying is that the reporting, there's two really sets of reports here to think about. There's a set of reports to the IRS, and there's a set of reports to the employees. And in both cases, under 6055 and 6056, and we'll be explaining that in a second, the differences between the two. If you're using paper, the deadline for the reports to the IRS is February 28th of 2016, but because that is a Sunday, that the date is March 1 of 2016, they are giving you until March 31 of 2016 if you file these reports electronically. Then on the set of reports that we'll be talking about that are due to employees, the date is January 31, 2016. Because that is a Sunday, the real date is February 1 of 2016, will be the due dates for the reports to employees. The IRS has said in their guidance that the actual forms will be made available in draft form at a later date for review and commentary. The other thing on this next page, just again reminding people, we spent a lot of time in the earlier webinars about what is an applicable large employer, and there was some comments in the guidance about the reporting requirements that apply to an applicable large employer member, and they're very clear in saying even though the determination of whether a particular entity is an applicable large employer, that determination is made at the aggregated group level or control group level, as Scott had talked about in earlier webinars. The reporting requirements apply to each member, and that is consistent with how the penalties are calculated under the employer shared responsibility rules. So jumping ahead to 6055 reporting requirements, the title of this is Information Reporting of Minimum Essential Coverage. And as you probably remember, going back into the Affordable Care Act, this Internal Revenue Code Section 5000A requires all of us, it requires every individual to be enrolled in minimum essential health coverage or to pay a tax, okay? So 6055 is basically requiring all what's called providers of minimum essential coverage to tell the IRS whether an individual is covered by minimum essential coverage and in what months during that preceding taxable year were they covered. A provider is defined as an insurer, and in that case, if you have an insured plan, the insurer is going to be responsible for the 6055 reporting to the IRS, but a provider is also defined as an employer when you have a self-funded plan. So if you look at this next slide, this is the type of information that the IRS is envisioning you as an employer providing them relative to 6055. So they're going to require that you provide the name and address and the employer identification number. They're also going to be, and this is a key thing, the name, tax identification number, or date of birth of each individual, and that means employee and dependents that was covered under the health plan. Now, this may send some shivers down some employers' spine about we don't have Social Security numbers for our dependents. And so they are providing as an alternative to that a date of birth. However, the guidance talks about you, the employer, are expected to act reasonably, that was the words they used, to get the tax identification number, and they're envisioning some type of an initial request and then 2 consecutive annual solicitations of the 10 numbers. And if you do that, there will be no penalty levied against you for failing to report a tax identification number. So in addition to those elements, you're also going to have to say, report to the IRS the months during which the individual was actually covered. And again, remember, if you're covered on any given day in a month, they are treating you as having minimum essential coverage for that entire month. What we just talked about was the 6055 reporting requirements to the IRS. The 6055 reporting requirements to the employees contain these elements. There would be a written statement that would be given to the employee, again, by January 31 of the following year to establish whether they were covered by minimum essential coverage and the months in which they were covered. Now, there is commentary in the guidance that this type of statement to the employee can be delivered electronically if the individual consents to receiving that electronically. And there's also comments about how that consent can be withdrawn at a later date. So I'm sure Caroline will be giving us guidance on that as we get closer to 2016.
Absolutely.
So, and again, for both the 6055 and 6056 reporting requirements, penalties for failure to report are waived if the failure was due to a reasonable cause and not due to willful neglect. I think I heard the same words being used by Caroline earlier when she talked about the HIPAA privacy practices. So we're going to switch gears into the 6056, the cousin of 6055, and this is, the title of this is Information Reporting by Applicable Large Employers on Health Insurance Coverage Offered Under the Employer-Sponsored Plans. So this is about reporting to the IRS about your compliance with the Employer Shared Responsibility Rules under 4980H, okay? This is designed, so you're going to report to the IRS about your compliance, but you're also going to report to employees so they can determine if they qualify for premium tax credits under this other Internal Revenue Code section 36B. So similar types of data elements will be required for you to report to the IRS. You see that the name, address, and your employer identification number. You're going to have to certify that you did offer minimum essential coverage to employees and their dependents, and the number of months that you did offer minimum essential coverage. You're going to have to disclose the number of full-time employees that you had covered in each month. You're going to have to provide the name, address, and tax identification number of each full-time employee who was covered by minimum essential coverage, and the months that they had coverage available and the months that they were actually covered. So it sounds like a lot of data you're going to need to assemble. You're also going to have to report the employee share of the monthly premium for self-only coverage under your lowest cost option. The IRS then goes into several other things that they are contemplating will be required. Some of these will be, they discussed, will be indicators. For example, does the employer's plan meet the minimum value standards? They will ask for any details about any kind of eligibility waiting period. They're going to ask questions about, did the employee have the opportunity to enroll his or her spouse? They're going to ask you with certain indicators, why coverage was not offered to an employee. For example, maybe they weren't a full-time employee, or maybe they weren't employed during a given month, things like that. And for those of you that are applicable large employers and part of an aggregated group, there's going to be a series of questions apparently regarding your membership in that controlled group. Now, this last item was that the commentaries that were released on September 5th do contemplate that the IRS recognizes that there's some redundancy here, I guess, is what you might say, and so they are looking at the W-2 reporting requirements that already exist under Section 6051, and they're looking at the reporting requirements that are being developed for 6055 and 6056, and they're looking at an opportunity to combine those. So they are saying very clearly in their commentary that they don't want to be overly burdensome to the employers, and they're trying to look at ways to make this more streamlined and efficient. So look for further guidance on that as we go forward. So a few comments about 2014 planning. You probably saw the news recently about UPS indicating that at least for non-bargained employees, that they were no longer going to make spousal benefits available if that spouse had coverage available elsewhere. We just saw on the news just this the last couple of days, Kroger over in Indiana has apparently adopted a similar position. I'm assuming it was part of collective bargaining, but I'm not clear on that. But there is clearly some movement out there in the ranks of the larger employers about spousal benefits. This is something we've been talking about in earlier webinars, and you will probably need to pay attention to this for competitive reasons in your respective industries. We are seeing some employers moving ahead with offering a bronze plan just to ACA eligibles. Some employers put those plans on hold when the delay was announced back in July. But others are going ahead, and they're going to offer such a plan only to, to the employee and the dependents, and not to the spouse. They're going to do what's minimally necessary. They're going to charge the employee for self-only coverage $90.96, which is 9.5% of the individual federal poverty level. The employee would then be expected to pay the incremental cost, the full incremental cost to cover dependents. But one of the things that Scott and I have been talking to employers about when they talk about offering only this bronze plan to ACA eligibles and not offering the ACA eligible, this means somebody obviously that has become eligible because their variable hours, they've averaged more than 30 hours during the measurement period. If they're thinking about offering the bronze plan only to this group, and this group only, that's their only plan that they have available, they don't have the ability to enroll in any of the other employers' plans. We have been cautioning, Scott, that watch out for 105H and what that means.
Yeah, there's been 105H has been in the code for years, but it's non-discrimination rules with respect to self-funded plans. Most of our clients would fit in the self-funded plan category, so it has meaning. The IRS government has yet to announce revised or updated non-discrimination rules under 105H, which would then impact insured programs. And so, the application of the 105H non-discrimination rules just need to be updated. They're just ancient. And so, again, they leave a lot of unanswered questions. And as it applies to insured programs, it's had the same kind of lack of definiteness. But anytime you start tinkering with who's eligible, who's not, what kind of benefits are provided, what are differences in benefit programs among different employee categories, you have to be cognizant of the application of the non-discrimination rules, because you could inadvertently run afoul of those, which then results in taxable income to some extent to the highly compensated individuals.
One other maybe checkpoint on, before I forget to mention this, is that for those of you that have non-grandfathered plans, As you know, effective January 1, one of the things you're going to need to do is cover the cost of clinical trials for cancer treatment. And there's been some question about when people have talked before about covering clinical trials, is that a wide open situation? The answer is no. It really is designed to cover cancer treatments. It doesn't extend to stem cell research and things of that sort. The purpose of me saying this is that I think for those of you that are non-grandfathered and self-funded, you're going to want to have a conversation with your stop-loss carrier to make sure you have the proper endorsements in place for January 1 to cover those clinical trials. Otherwise, I would hate to see something excluded because the stop-loss carrier is still operating under exclusions that relate to investigational or experimental treatment. So remember to talk to your stop-loss carrier about that as your policy comes up for renewal for January 1. So I think we have time, Lisa, for questions.
Yes, for those that would like to stay on the line, we will answer the questions that have been submitted via chat.
So one question we have up here is, are we confident that the Affordable Care Act Government Data Hub will be held to the same privacy standards that the rest of us are? That's a good one.
It's a good one, and I don't know the answer to that. I guess I could say I hope so, but it's definitely something that I can, look into as we get, further in that process, exactly how they're going to be protecting that. But I honestly,
protected as to private citizens versus the NSA.
Thank you, Scott.
So another question, is there a model notice of privacy practices?
That one I can't answer, and from my knowledge, I do not know there to be a model notice. The only document that there is kind of a model for right now is the new business associate agreement. HHS does have what you can use as a model to kind of pick and choose between provisions, and that's really the only model that I know of.
We could help someone.
Oh, absolutely, yeah. There's no model on like the HHS website for the notice,
you can
yeah.
Email one of us, and we can help you with that.
Excuse me, absolutely.
Let's see. I'm reading this question here. Let me go to the next one here. Does the employer's contribution change the minimum value of the plan? And that's no, it does not. The minimum value is not tied to the employer's contribution. That's really relates to the affordability requirement. The minimum value is going to be basically
an actuarial determination of value covered by that design.
The exception to what I'm just saying, though, is that you do take any kind of employer contributions to an HRA or an HSA into account in establishing the minimum value, but the actual contributions to the plan are not taken into account. Is all this reporting for medical only, or do we need to include dental, vision, flex, etc.? And it's my understanding that any kind of freestanding or HIPAA-accepted benefits
are not part of that.
Not part of this. Right. This is your medical and prescription drugs. But again, if you have to be careful if you have a bundled approach with your dental and vision. If it's bundled into the same contribution for medical and prescription drugs, you're going to need to watch that. You may want to, if you haven't done so already, maybe unbundle those.
Right. I guess it also depends on what you're talking about, like with SBCs, for example, too. For anything that's considered, a group health plan, like EAPs, that kind of thing can be included in an SBC if it provides medical care.
Right.
So it just depends on what exactly we're talking about.
Right. Scott, here's one. Has there been any clarification on the 90-day waiting period?
No.
In some cases, in our case, the employees are eligible to enroll in medical the first of the month following 3 months of service. Does this comply?
I've actually debated this a little bit with some other practitioners. You know, the shared responsibility guidance talks about application of that tax and provides that there's, I'll call it, no application of the tax with respect to the person who enters the plan or can enter the plan the first of the month following 90 days of service, which would imply that it's kind of a 90-day rule, but not a hard and fast. If you get hired on March 3rd, count 90 days later, and and that's the exact enrollment date. So I guess I really kind of wonder about what the right answer is. From a practical standpoint, from an administrative standpoint, you'd like a little wiggle room in terms of a nice administrative date like first of the month following. Right. And that doesn't seem to be inconsistent with where the goals of the law of getting coverage, et cetera. Right. But don't know the absolute right answer. Right. If you're paranoid, just count 90 days and enter them.
For a second to the one that's highlighted, too.
As an employer in Ohio, if we add same-sex domestic partners to be an eligible FMLA family member, would that be problematic?
No, I mean, you can do that. In fact, Findley Davies, we adopted a policy several years ago. I refer to it as FMLA-like because the same-sex partner is, not treated as a married individual in Ohio, and even under that recent DOL announcement, they're not. But there's nothing that prohibits you from adding the individual or treating that individual, that same-sex spouse, as eligible for FMLA leave. It's just that when you do that, as I try to create the example in my segment of the presentation, that's not going to result in used up time for FMLA. We're not going to be able to offset that against any other FMLA event. So it's okay to add that person, treat them like eligible for FMLA, but in Ohio, I'd say right now that the same-sex partner or same-sex spouse is not going to really be treated as an FMLA person. You're just created a generous, diverse policy statement with respect to your program.
Our company holds their open enrollment in March with an April 1 renewal or effective plan date. During that time, we annually distribute a privacy notice. As a result of the September 23rd date, are we required to share a new updated notice now, or are we able to wait until next March to distribute?
You have to do something now or close to now.
Reasonable, yeah.
If you have an intranet, the HIPAA rules have always stated if you have an intranet or a website where you post benefits information, this privacy notice has to be on that intranet. That's per the rules. So if you have this intranet, you have to post the new notice, the revised notice on the intranet by September 23rd, and then in the plan's next annual mailing to plan participants. So that could be open enrollment. If you're sending nothing out before then, that's questionable. So whenever your next annual enrollment is, you either need to send that revised notice or just a small blurb about when it needs to be, what is included in the material changes and where you can find it. If you don't have an intranet, then you do have to send the whole notice or this blurb within 60 days of the material change, which is November 22nd.
So we have a couple of more questions, but I think considering the time, I want to be respectful of your schedules. We will go ahead and answer these additional questions online when we post the audio recording of this tomorrow. Lisa Kay is making arrangements so that the slide deck is available on the website, so you'll have access to that. But you'll be able to also get the audio recording tomorrow and look for the FAQs as well. So again, thank you very much. If you have some ideas about future webinars, if there's some particular things that you feel that we didn't cover well enough, or if there's something that we have not yet covered, we'd like to hear from you so we can plan accordingly and continue to serve your information needs. So again, thanks very much for your participation. Have a good day, good evening. by